No, I totally agree. Where's my little notes here? Welcome to the committee.
Thank you. Good morning.
Remember.
Whenever, shall I go right ahead?
Yes, please do.
Thank you. I'm very pleased to present to you today AB 2295. And first, I'd like to start by thanking Senator Glazer for co-authoring this bill that has received no votes out of the Assembly. This bill addresses an ambiguity in the California Penal Code regarding a victim's right to full restitution. 2008, California voters passed Proposition 9, known as Marsy's Law, which provides certain enumerated rights to victims of crimes, including victims of assault, abuse, homicide, robbery, human trafficking, and other violent offenses. One of these rights was the unconditional right for a victim to receive full restitution from the offender to compensate for their loss. Victims of crimes must be compensated and provided the resources to recover, according to California voters. Prior to the passage of Marsy's Law, the Penal Code in California allowed courts to provide less than full restitution when there were, quote, compelling and extraordinary reasons to do so. Currently, Marsy's Law mandates that restitution shall be ordered from a convicted wrongdoer in every case, regardless of the disposition or sentence imposed in which the crime victim suffers an actual loss. And despite the passage of Marsy's Law, there are ambiguities in our current penal code. The penal code has not been updated, and it's inconsistent, and it's actually leading our courts to some lack of clarity on what they should and should not do with respect to restitution. For example, an appellate court noted this inconsistency in the case of People versus Pierce, which was published May 6th of last year. In this case, the appellate court questioned whether the court had discretion to provide only partial restitution and if that was constitutionally sound in light of Marsy's Law. So what we'd like to accomplish today with this bill is to make sure we conform our penal code to the constitutional amendment that was made by California voters. And in doing so, I believe that victims of crimes would be guaranteed the right to receive full restitution that our constituents across the state asked happen. In addition, I think it's very important for our courts to have consistency so there aren't further appellate review of their cases for this. It is conserving judicial time if we can take care of it now rather than wait for additional cases to rise. And for these reasons, I respectfully ask for your aye vote. I have some witnesses joining me today from the District Attorneys Association and Crime Victims United.
Thank you.
Thank you. Good morning, Madam Chair and members. Dawn Kepke with McHugh Kepke and Associates on behalf of Crime Victims United, sponsor of this bill. Really pleased to be working with Assemblyman Baker on this. As many of you probably know, Crime Victims United worked very hard for the passage of Proposition 9 and Marsy's Law to provide these constitutional rights for victims. And in that regard, really felt very strongly about ensuring that full restitution was available and provided to victims who suffered a loss based on a crime that they would have no part in bringing upon themselves. And so for these reasons, we really think it's very important to make sure that the courts do have clarity, that the ambiguities are addressed and conform to the rights provided to victims as part of the constitutional rights in Proposition 9. So for those reasons, we very strongly urge your support of this bill in addressing that lack of clarity and discrepancy between the Constitution and the Penal Code. So thank you. We urge your aye vote.
Sean Hoffman with the California District Attorneys Association here in support of AB 2295. As the author and my colleague from CVU stated, this really just picks up the encouragement of the Pierce Court to address this ambiguity in the inconsistency between the Penal Code and the Constitution after the passage of Prop 9 back in 2008. We think it's a pretty simple and straightforward measure and ask for your support.
Madam Chair, members, Dan Filozzato on behalf of the Los Angeles County District Attorney's Office in support. This bill builds on a bill that our office sponsored last year to ensure that victims of juvenile criminal acts are entitled to full restitution. This is kind of a natural extension of that. We ask for your aye vote.
Thank you. Are there other speakers in support? Are there speakers in opposition? Seeing and hearing none, I do have some questions about this. Clarity in the law is one thing, and it would seem, if it's in the Constitution, we might want to reflect that in our statute. I'm really, this got me interested in the real-world application of this. I strongly support victim support and having victims made whole. I'm wondering what our experience is. I read the Victims Restitution Guide, and it seems that victims must actually apply for this, right, and go through a fairly lengthy process to do that. Do we know what percentage of victims actually do?
Madam Chair, I don't have an exact number for you. Certainly, we can follow up with victims' compensation and help provide that number. I will say that, yes, indeed, you are correct, that victims do have to provide victims' compensation with their contact information and make sure that they have proper information on file so as to ensure access to that restitution and through CDCR, et cetera. But I don't have that specific number, but I'd be happy to work on getting that for you.
Thank you, because I did ask CDCR, and they say they don't have any valid data on that. So do district attorneys' offices undertake the collection?
The district attorney's office doesn't undertake the collection. Typically, obviously, if a defendant is sentenced to state prison, then the Department of Corrections Victim Services Unit will handle restitution collection. However, inmates who are in our state prisons generally don't have access to any real significant sums of money absent extraordinary circumstances. However, when a victim is, or excuse me, there's a case where an individual is either sentenced to our county jails and then placed on probation, the probation departments, in felony cases, the courts in criminal or misdemeanor cases do the restitution collection and make sure that disbursements are made to the victims. In Los Angeles County, when we have a crime and there's a victim where restitution would be required, part of our case file is to contact that victim and to try to obtain what would be the necessary restitution. For example, in Los Angeles, a lot of cases I handled, in downtown there were a lot of, let's say, the graffiti cases, we would contact property owners or if it was City of Los Angeles, whoever, to find out what the costs were for the restitution. In a crime of violence against an individual.
Well, so let's just take the graffiti.
Okay.
And they'll say, it cost me $200 to paint it over.
If the,
Yeah.
generally what we'll ask for is some kind of proof to ensure that if let's say the graffiti removal cost $200 and they say it cost $2,000, we would require that they show some kind of proof of what their actual loss was. When it's an individual and you're talking about merchandise, then it's kind of a fair market value unless they have actual receipts.
And Madam Chair, if I may, going to your original question as well, which is what percentage of victims, I don't have the percentage either. We're talking about real world, actually having represented victims who of embezzlement crimes, nonprofits in my district that were had embezzled by someone, an officer of theirs. The crime was prosecuted by our local district attorney, but it was absolutely, they wanted the restitution. And it was a difficult process, even with the great help of the district attorney's office, to try to substantiate the claims. And a financial case is one where it's a little bit more straightforward on how you would monetize what that is. But I can't imagine, and I've seen from clients that I've actually represented before coming to this building, who want and need the restitution. One was a local school nonprofit board, a parent-faculty club, and they needed those funds to continue the work that they were going to be doing on behalf of students and a local school. And it takes a long time. It's very onerous. It kind of adds insult to injury if they go before a judge who's not sure if they have discretion or no discretion on whether or not they're going to be ordering that full restitution. In addition, this bill was originally inspired by a constituent of mine who had been the subject of a financial crime and someone who was actually very close to him, and it took him years to get restitution, and he's been an advocate for victims' rights and making sure that full restitution is possible. So these are very real-world experiences of the victims who, even though I don't have the percentages for you, have absolutely made it clear to my office and my own work experience that they need that restitution, and it needs to be full.
No, I understand that theory. One of the things that was of interest to me is what happens in class actions when there's white-collar crime, embezzlement. People really, a nonprofit organization, a for-profit organization, a county is, the victim of that. In the real world, maybe your case is a good example. What happens when the perpetrator is put in state prison? Was your particular perpetrator put in state prison?
As I recall,
or was it a civil fine of some sort?
there was a fine. It wasn't civil. It was a criminal case, and most class
Okay.
action cases are civil cases.
Yeah.
And in that particular instance, she was sentenced to time, and I believe she was credited also with time served. But there was a restitution order after a very long time for the victims. I don't know. Again, I've deferred to our
Yeah,
witnesses
but-
who are on the
and it
day-to-day.
wasn't deferred or anything, so it would be covered under current law. Well, current law does say, unless there's extraordinary circumstances, full restitution is required.
Well, the Constitution says that our penal code does not.
I
Which
thought
is
the,
purpose.
okay,
Yeah.
maybe I'm missing
The purpose
something.
is to conform
The purpose
our
of this
penal
bill
code to our
is to
Constitution.
take out the extraordinary circumstances provision that would allow restitution not to be charged, was my reading of the bill. That the Constitution, one of the things that was confusing to me was it seems like the Constitution may still have that in it.
The Constitution has Marcy's Law, which says full restitution for victims. The penal code does not conform. So we're conforming our statute that judges also read and their clerks read as they're determining a sentence with the Constitution. And
Right now, depending on the court, most courts are actually implement California law correctly. However, there are courts where when restitution is ordered, the judge will say, in this case, I'm not ordering full restitution to be paid, at which point, and they'll do it pursuant to the statute because they're reading the code. At that point, the district attorney has to stand up and explain to the court, while the code says this, the California Constitution actually requires that you order full restitution to be paid.
Yeah.
What this bill will do, like last year with our bill by Senator Leyva, is simply conform the codes to the Constitution, removing any ambiguity that's in current law in case a court is only looking at the codes. For example, I had a case where we had a judge who was sitting in our criminal court on assignment. He was a civil court judge. Wasn't familiar with California's restitution laws because he's a civil court judge. He had the codes in front of him, wasn't aware of the provisions in the Constitution.
No. And am I right in saying that I believe what this bill does is remove the clause in current law that says the judge can adjust or waive restitution in extraordinary circumstances?
That's correct.
Okay, period, full stop. That's what we're talking about, okay.
We are, which is what Prop 9 removed that.
I understand.
2008.
I understand. I'm taking advantage of this opportunity to learn something, because I honestly think that we may want to revisit this at some point. It's sort of like our fines and fees. Let me put it this way. I did a bill a few years ago that involved taking of property when it had to do with illegal dumping and whatnot. We got into a great discussion around, can you confiscate the truck if the spouse uses it? So, to get to work or whatever. So, my question would be, we put the perpetrator in state prison. to get restitution, how does the law work? Would they need to sell their home? Would they need to have their bank account emptied to make restitution? What in the real world happens to actually get this transfer of money from people with assets?
If an individual has assets, in the real world, several things can happen. When there's large sums of money that are stolen, embezzled, whatnot, the courts will frequently in the real world sit there and say, if you make full restitution, they will provide a more lenient sentence.
Yeah.
If an individual,
If you make full restitution, they will lower the sentence?
in a lot of cases, the court will do that. As a, they're not going to let you completely walk.
Lower prison time.
Right.
for people with assets. Got it. Continue.
Well, for those who can meet the restitution, the victim that they
These are
affected.
These are probationary cases, not state prison type cases.
So these would be, okay, got it.
But in the real world, if you have assets, the court doesn't have the ability, or the DA or the probation department on its own, to go and seize anything. They can't seize your bank account. They can't seize a home. Restitution is ordered if you, once again, if you're in state prison, unless, that's why restitution orders are basically stayed and can be collected civilly.
Yeah, well,
after the fact.
restitution orders, I know that you can take up to half a person's prison account
Correct.
on an ongoing basis, but they
Right.
make like $1 an hour, the lucky ones that have jobs, so you're not going to pay
That's
back
why-
a big,
That was my point about individuals in state prison. However, as far as an individual, even an individual in state prison, their bank account over at Wells Fargo, the DA, the probation department, the court don't have any ability to go in and order that account be seized. However, if an individual does not make their restitution and they have an ability to pay, willful non-payment of restitution is a separate criminal offense. An individual who is on their criminal sense, their probation, their parole, their PRSF, whatever it would be, at the conclusion of that, the restitution order can be converted to a civil order, and a civil court can order a defendant to make payments. A civil court has greater ability to go in and then order items seized.
they would do something like garnish a person's salary or something.
They can.
Or they could force the sale of assets or the savings accounts, that kind of thing.
Within the law, how the law is allowed for, for instance, I'm sorry, I'm not familiar with civil law, but as far as I know, like with bankruptcies and collections, they have ability to collect monies, but certain types of assets are protected and can't be seized. And I'm sorry, I'm not familiar with that.
And these are great questions, Madam Chair, that we may be able to work together on some restitution reforms.
Yeah.
I do, just by way of affirming that this particular measure, however, is quite limited to, again, conforming our penal code to what is already in the Constitution for the very reasons it's causing ambiguity in our court system that have been given in examples. And I hope we'll have an opportunity to work together on restitution.
I understand the clarity issue. I truly am in a way, this could be a fantasy land if you can't take someone's savings account. I'm thinking of some of the real consumer fraud cases we've had. You can't actually get at the assets. And then there's the other side, which is that most perpetrators are pretty indigent people. So let's say somebody goes to state prison for a burglary or something, and they've got $10,000 that they, let's assume, would have to pay back in restitution. If, I suppose, if the stolen goods weren't recovered, and they're pay it back 50 cents on the dollar, and they have a prison job for a few years, so they paid back $200 at the end of that time. And then they try to get a job as say, a garbage worker, would typically then a civil court garnish their wages? Or, again, how
Sure.
would that work?
And I
What would the impact of that be?
and certainly will defer to those who are on the front lines of it more. I know as someone who's represented victims in those cases, they were also not of great financial means. They needed
that's
that
true, of
to,
course.
and even if the restitution is scheduled over a very long period of time, but they also, some of the local nonprofits that I represented who were the victims of these very crimes were ones that they needed the resources to do the work they had. So I'm
No, I
a little bit more
appreciate
experienced
that.
with that side of it, but happy to defer again to our good witnesses.
Yeah, strikes. Okay, I have two other sets of questions, Senator Monning and Senator Stone.
Thank you, Madam Chair. And I appreciate the author bringing this forward. I fully understand the objective of trying to reconcile how our courts function with constitutional obligations. But let me come at it a little different way. For the author, do you see any circumstance where preserving the court's discretion in determining appropriate restitution, that the loss of that would indeed be a loss to serving the ends of justice?
See, I actually don't believe they have the discretion now because Marcy's law is in our Constitution. They have some discretion with respect to restitution fines, which are different, and then what the type of restitution that we're referring to now. But our Constitution already, and our California voters have already removed discretion with respect to full restitution. Restitution fines and other matters, and the judge will still have discretion on how to order that and structure that restitution for the specific circumstances that meet that victim, that crime, and the perpetrator there. This bill does not change that discretion at all. It does affirm the discretion that's already in our Constitution.
Thank you. So you distinguish between a restitution fine, which can be imposed by the court as part of a mandatory fine for court costs, et cetera, it's not restitution to a victim, it's a court cost or court fine. You're suggesting the court still would have discretion in that area?
Correct. Marcy's law and this bill do not change that discretion.
Thank you.
It doesn't change, again, the judge's discretion on how he or she structures the restitution order with respect to timing, how frequent. It doesn't change the discretion that civil courts have if a restitution order goes into civil court. That discretion remains. It reaffirms, again, the commitment that there is no discretion now with respect to full restitution and conforms our state code.
Back to the restitution of a victim, which we're talking about here, and the bill requiring full restitution. And to use the chair's example, let's say restitution calculated at $10,000. The defendant, the convict, is indigent, gets a sentence, and presumably that sentence, let's say, includes prison time, and usually that is going to also include an order of restitution. Am I correct? That would be part of the sentence. If the victim is out $10,000, would it be fair to assume that part of the sentence, whatever county jail time, prison time, and restitution in the amount of $10,000?
In the criminal sentence, there's either a county jail, a state prison sentence. Then if there is a victim,
Right?
then there is a restitution order, which is the court order to make the victim whole.
Right.
And then there is a restitution fine, which is monies that go to the state into the penalty.
Let's just go, my question just goes to the restitution order, that our $10,000 example. So convicted, going to county jail or prison, That's part of the sentence. Is it fair to say that part of the sentence is that restitution order to pay the $10,000 to the victim?
It is part of the sentence, correct.
Okay, thank you. So using that scenario, can the time served by that convicted defendant be altered based on his or her ability to pay that restitution?
And if I may add, again, not what our bill changes. If we, and there may be opportunities to address that underlying question, this bill does not change that. This bill is
Okay.
very narrow in that
You
regard.
understood, but still, is there a response to that question? Can the time imposed or the time served be a function of the ability of
Does it depend on the
repaying?
crime that's at
No.
the particular crime?
If a court orders a defendant to serve a period of incarceration,
Let's say 3 years in state prison, and pay
$10,000.
$10,000 back to the victim.
If in that case, the individual would have to serve their time and pay. A defendant who has a 3-year state prison sentence and a $10,000 restitution order would not have their state prison time reduced by making full restitution on their order.
Or conversely, extended.
Or extended.
For the end.
Correct.
They serve their 3 years, maybe they get some credit for.
We do not have any kind of a debtor's prison.
Got it. That,
That's existing law.
yes, thank you.
Which this does not change.
Got it. Thank you. Thank you, Madam Chair.
Okay, thank you. Senator Stone.
Thank you, Madam Chair. It just seems this is a very clear bill as far as just conforming the will of the people through Prop 9 and what exists in penal code to eliminate any gray areas of the law when it comes to judges imposing the rightful reimbursement to victims. And just brings to mind for me the Bernie Madoff debacle, where you saw hundreds of people that invested in his Ponzi scheme being wheeled out of rest homes in Florida. And actually, they've been pretty successful in actually getting some restitution back for some of those victims. Obviously, a very large case. But the bottom line is that we always talk about the propositions and the people speak, and this is a constitutional amendment, and that should be the prevailing guideline for judges to utilize. And with that, I'll move the bill.
Thank you. The bill has been moved. Did you want to say something, Senator Glazer? Okay, thank you. Thank you. Yeah, I mean, I think the issue before us is the conforming. What I wanted to flag, quite frankly, is I think this is deserving of a hearing because I want to be sure, too, that when you have people of means who deliberately defraud other people, and they should be victims' compensation. And as Senator Stone mentioned, Bernie Madoff. You think of all the people whose mortgages went underwater and lost their homes and were not bailed out. So I think we do need to look at that. I'm also concerned about literally, would we go into that garbage worker's account and garnish some percentage of their salary? And then what if they were indigent, and what would that do to safe neighborhoods and recidivism? You know, so, but those are policy issues for another day, but
Happy to work with you on them.
yeah, thank you. Good. I think that would be very good. So would you like to close?
Well, I thank you for the
Assemblywoman.
discussion, and I respectfully ask for your aye vote.
Thank you. Please read the roll.
Hancock.
Aye.
Hancock, aye. Anderson.
Aye.
Anderson, aye. Glazer. Glazer, aye. Leno. Liu. Monning.
Aye.
Monning, aye. Stone.
Okay, we're going to hold the roll open for the absent members.
Thank you.
And we are going to recess for 20 minutes until 10:30 when we have our time certain
Thanks again, Madam Chair.
schedule. Thank you, Assemblywoman.